So, hello everyone. Just in a few words, AFG is a French fund association, and out of 600 management companies based in France, AFG is composed of more than 400 of them, 400 management companies, and managing either UCITS funds or the whole range of non-UCITS funds, which are now called, in a European way, alternative investment funds. I will speak about the EU industry view in spite of representing just one country. So I will express more a French perspective. However, in terms of figures, you have to be aware that in terms of domiciliation, for instance, France is the second domicile of funds in Europe after Luxembourg, but before Ireland, for instance. And in terms of management of funds, France is the first management center by assets under management ahead of Germany and the UK for the whole range of funds which are domiciled in the EU. So I think that in terms of, I would say, interest in EU concerns or issues, I think our members, the French fund companies, have significant interest in following them. Number two, in terms of EU investors, France is also the first market for funds. So I would say the top market for funds is in France, and also from an investor perspective, therefore, we have to be very careful about the confidence of investors. Number one, because, as I said, many investors are based in France, but also because many French management companies export their funds across Europe. Currently, more than 2,000 French domiciled funds are registered across Europe. So once again, speaking about investor protection is crucial for us, and keeping such investor protection is key, because we think in the long term, we need the confidence of investors in the long term, because the management fees which are got from the management companies are based on the stability in keeping the investors within the funds. So basically, I will split my short speech in two parts. What are the intentions of European institutions and what is the reality? This is a slide on what is the intention of European institutions. Of course, I will stress mainly on the current texts which are tackling directly or indirectly funds. Investor protection is currently being reinforced officially by European institutions. I will not be very long on that slide because I think that most of you know more or less the content of each of these topics. But as you know, the UCITS 4 directive implemented or adopted as a key information investor document, which was a way to harmonize information towards retail investors on UCITS funds across Europe. In the context of AIFMD, there was the intent expressed by the European Commission, apart from systemic risk, to tackle also investor protection in spite of a passport restricted to professional investors, because, for instance, pension funds are in the scope of the passport of AIFMD as targets, but behind pension funds you have retail investors. So clearly it was an official goal for the European Commission to tackle also investor protection in AIFMD. More recently, in July, the Commission issued, among others, new proposals on UCITS 5 and PRIPS. And in the meantime, there is currently the negotiation on MiFID and MiFIR. On MiFID and MiFIR, as it was mentioned by Guillaume Prache before me, among many topics in that file, there is a discussion on inducements. To which extent should a ban apply to commissions paid between product providers and product distributors? It's a notion of, basically retrocessions in the context of investment advice service, and also in the context of individual portfolio management. And as I said, more recently in UCITS 5 and PRIPS, these two files were issued with still the official intent of investor protection in mind. In UCITS 5, it was following the Madoff case, which hit some UCITS funds in Europe, in particular in Luxembourg and Ireland. So the idea was basically to reinforce the protection on the depository side of UCITS, also to reinforce the rules to be applicable for remunerations of managers, and also to implement compulsory or mandatory administrative sanctions by national regulators in the area of UCITS management across the whole value chain of players. For PRIPS, once again, in terms of investor protection, the idea is basically to provide for the same level of information for a wide range of retail investment products. And I will come back to that later on, but based on the KID inspired by the UCITS KID. But what is the reality? And I think it's the most important point. I'm afraid that until now, at least, the reality is not really, the aim of investor protection is not really achieved yet. Just in the case of the UCITS 4 and the harmonization of the KID, just as one example about the so-called TER, total expense ratio, at least in the industry, many of us know that, for instance, some costs are charged to the fund in some countries, while they are charged to the management company in other member states. Maybe it's not very meaningful for some of you which are not so used to the, I would say, the structuration of costs in funds, but it means basically that if the costs are charged to the fund, it means that ultimately they will have to be paid by the investors, while if they are charged to the management company, they will not, the investors will not have to pay for the costs. And for instance, it's just a single example where harmonization is not achieved yet in terms of investor protection in a harmonized way across Europe. It was also true in the case of eligible assets, still in the UCITS 4, or in the UCITS framework. ESMA is trying to harmonize in a better way the eligible assets which are eligible for UCITS, but I think the harmonization is not achieved yet. In the case of AIFMD, I think it's a very interesting case as well from a different perspective. In AIFMD, as you probably remember, there was a big fight and discussion on extending the benefit of the passport for non-EU players and non-EU funds, non-EU alternative investment funds. The point is potentially the following. Potentially, there is a passport which will be extended to non-EU players and non-EU funds from 2015. The point is that if this passport is agreed, because it will depend on the final advice of ESMA, which is not delivered yet, it will mean that the only remaining point in Europe will be the investor. And it will mean that in practice, if a passport is given for a non-EU fund managed by a non-EU manager to sell their products to an EU investor, if something bursts out, it may happen, the investor will have to go out of the EU, to the courts, out of the EU, to get their money back. And if you look just in a recent case in the Iceland bankruptcy, what happened with the UK pension funds, if you think about the difficulty that UK pension funds found in getting their money back from Iceland, which is, however, part of EEA, so supposedly it shouldn't have been so difficult. Could you imagine what would happen if a fund sold officially and passported from a non-EU country? Can you imagine in that case how the investors could get the money back? We are very skeptical in terms of investor protection on that point. And regarding MiFID, coming back to the point of the so-called inducements, in fact, to be frank, and it was officially published by the Her Majesty Treasury 3 years ago, following the RDR intent in the UK, which is going to take place in January next year, 2013, 3 years ago, the Treasury officially wrote in a public report that they intended to export the RDR approach to the whole Europe in order to keep, I would say, the UK industry competitive, in line in terms of competition with the continental industry, which is fair from a UK perspective. But we were considering that if there was no significant case, and at least in France there was no significant case of mis-selling on that basis of inducements, we were considering that it was probably a wrong approach to be applied at EU level. Currently, the debate is to know to which extent there should be a ban on inducement or not, only to independent advisors or managers or not. So the debate is not over yet. But what we think is that ultimately, if there is a ban on commissions which are paid from product providers to product distributors, it will basically mean that the choice of products which will be offered by distributor will be reduced. So in terms of, I would say, ultimate, optimal offering of performance and products, the choice will be narrower. Number two, it will reduce the number of producers. And if you reduce the number of producers, you reduce competition. And therefore, you will increase the cost for investors. So I think that tackling investor protection, just keeping this example in mind, I mean, everyone, and especially from a French perspective, we think that investor protection is crucial, as I said, to keep the confidence in the long term or medium term. But the difficulty is to know where to and how to implement it. And for instance, I took the case of inducements to say that even if the intent is, I would say, noble, the effect might be the reverse of what is supposedly aimed at the beginning. And last point on UCITS 5. UCITS 5 also was issued in July, basically on depositories, administrative sanctions, and remuneration for managers. I will just stress one point. In principle, administrative sanctions should be imposed in all member states in order to make sure that the reinforced rules of UCITS 5 will be applied in the same way across Europe by all national regulators. And currently, in the Council discussions, it seems that a majority of member states are now taking the case of the MiFID negotiation, where administrative sanctions might be just optional, to say if it is optional for MiFID, it should be optional for UCITS. Okay, but what will be the ultimate result? Like in Luxembourg, we are still waiting for the judgment by the courts, by the criminal courts, regarding the Lux Alpha UCITS fund, which was passported thanks to the UCITS passport. So we are still waiting for a judgment 4 years after the facts. With administrative sanctions, clearly, you would have had a prompter result or outcome for sanctions or not sanctions. And so we think that if, as it is currently apparently the trend in the Council, the repeal of mandatory administrative sanctions is approved, it will not lead to a reinforcement of harmonization, but on the contrary, it will lead to a sort of polarization. Some countries will get mandatory regimes of administrative sanctions, as it is already the case today for some countries, but others will choose not to apply them. And therefore, the idea I have is basically that even if you reinforce the rules in principle, but if they are not applied at all in the same way because of sanctions in one country and not in other countries, what is the aim? So basically, as my final conclusion, to be frank, we have to make a clear split between, I would say, political approach and reality. I fully understand that politicians and European institutions as well want to claim politically that they reinforce many things in terms of safety, in terms of systemic risk, or in terms of investor protection in this case. But once again, I think that the importance is not just to have a political gesture and not just to be concerned about the promptness at which the European files are adopted. The main point regarding investor protection is to make sure that they are really implemented. And therefore, I think what is crucial is to get an harmonized implementation, harmonized sanctions across Europe in terms of regime, in particular administrative sanctions, and ultimately, but I would say not in 10 years' time, but in very few years, a single regulator, but I mean a real regulator with an enforcement power. Coming back to what Guillaume was saying before, I think that the issue of enforcement And harmonized regimes for sanctions are crucial because otherwise we'll stay at the level of blah blah regarding investor protection. It will be good politically, but without no real effect. And ultimately, the industry will suffer as well. Because once again, at least for funds, we need investor confidence.